Good morning. This is Judge Middleton here at the court in Centerville. Which case are you here for?
I'm here for the Deontay Williams. I'm the victim advocate in Cass County.
All right, thank you for being here. Is she with you?
No, she's not going to appear today.
All right. Well, thank you for appearing. I'll put you in the waiting room for just a minute till everybody else lines up. Thanks.
Thank you, Judge.
Good morning, everyone. We're waiting for Mr. Williams to get fully logged in here. Thank you for logging in a timely manner.
Morning, Judge.
Good morning. Morning, Mr. Gibson. Mr. Williams, can you hear me?
Yes, sir.
Good morning.
Good
This
morning.
is the time and date for sentencing in the matter of People versus Deontay Stephen Williams, file 201141FY. This matter has quite a long history. Actually, the offense allegedly occurred last June 8th of 2020. Here we are at the end of June 2021. There were several problems. We had to get a special prosecutor. There were a number of delays that were regrettable. I'm not sure if they were avoidable. Then the matter was charged as a felony, set for a pre-exam conference. The defendant then entered a plea. Matter was scheduled for sentencing today. Mr. Victor Fitz, the Cass County prosecutor, who is the special prosecutor in this case, is present. Also Ryan Funk from the Cass County prosecutor's office, and their victim advocate, Marie Anderson. Mr. Williams is here, and he's represented by attorney Paul Gibson. The defendant entered a plea to domestic violence and disturbing the peace. Charges of child abuse in the 4th degree, 2 counts of assault and battery, and home invasion charges were all dismissed. And I did receive a formal nollie-pros from the Cass County prosecutor's office yesterday to that effect, and I will sign it. So what's left after all this time is for the sentencing for the events that occurred on June 8th. I believe the plea agreement envisioned a domestic violence deferral. There's also a disturbing the peace charge, which we'll deal with, but I don't need a probation on that count. So, Mr. Gibson, let's start with you. What would you like me to know?
Your Honor, the defendant attends Davenport University in Grand Rapids, and he's working on getting, I believe he is either close to getting his degree or he has gotten his degree. He indicates that he wants to try to get into the field of digital forensics. So my understanding is that's maybe computer type skills, I guess, also mixed in with possibly being in a form of law enforcement, or at least assisting law enforcement. So it's very important for him to hopefully keep this off of his permanent record. So he wants to be able to hopefully, use his degree to the fullest of his abilities. And so he's asking the court to permit him to have the deferral and give him a chance to earn, I guess you could say, earn the treatment of the deferral and then not having on his permanent record. Thank you.
Mr. Fitz, what's your position here?
Your Honor, do you want my entire elocution or just an answer to that particular question about deferral?
Oh, we'll hear your whole elocution.
Thank you, Your Honor. Your Honor, I'm going to take a little bit more time than I normally do on these cases because I think there's some dynamic to this that certainly merit that. And I'd start out by pointing that this defendant does have a 2014 conviction for retail fraud, also a 2019 domestic violence that was dismissed. He's bottom line, Your Honor, he's a man who's playing with fire. He's had some good advocacy by his attorney, which really doused a lot of the flames on this case and got him a resolution that he really needs to understand is a very fortunate resolution and something he needs to take full advantage of. And I'm going to be pretty frank and harsh with the defendant on this because I think he needs to hear it. There's commentary that says that a wise man learns from a rebuke and a fool continues to be a fool. So I think really the question for the defendant here today is, are you going to be a wise man or are you going to continue to be a fool? Because you certainly have been a fool in the way you've dealt with your life at this point. And I'm sure there's many good aspects of your life, but your involvement with the criminal justice system has been reprehensible in what you've done. I just note, Your Honor, that this defendant as the court, I'm sure, is aware, he assaulted his girlfriend who was holding his 2-month-old baby. I mean, that's not the actions of man. And now he's shaking his head no. But again, we'll go some other things that he does agree on, Your Honor, that I think even he can't escape as far as his acknowledgement. But again, that's certainly what was reported by other persons. And again, any type of drinking and disagreement that becomes physical with a child involved, that again is something that is reprehensible. I note, Your Honor, that from his own words, he could very easily, and I've done this for 38 years. And so, Mr. Carter, I've been in the line of work that you say you have some interest in being in. So I'm going to tell you real clear, I've tried over approximately 200 jury trials, and I know what is required to achieve a conviction. And it would have been very simple to convict you of a 5-year felony in this case for what you did. Let me read your own words as to what you did. You said that, and this is coming from the statement that you gave, that you went over to the guest house where the grandparents and the baby were, and you tried to get the baby back, at which point Donna Thrasher said you couldn't have the baby right now. Deontay stated that he tried to get into the door that was blocked by Donna and her boyfriend, William Naveau. Deontay stated that they were trying to keep the door shut, slamming his arm in the door. You can't go into somebody else's house when they say don't go into it. And when you do, under those circumstances, you're committing a 5-year felony. And again, you're very fortunate that you had an attorney that, again, got you the resolution that you had here. Because if we had gone to trial, I'm extremely confident you would have been convicted. So do you want to continue being a fool, or do you want to be a wise man and learn from this rebuke? It's going to be up to you. You may again, have a rebuff to these words. You may be thinking these things are ridiculous, what you're hearing right now, but you need to think about them in the coming days, because again, I've done this long enough to see many people in your shoes, and you've got 2 forks in the road here that you can choose. You can continue to be a fool, or you can learn from this rebuke and go on to have a good life. I would ask, Your Honor, that the no contact provision be continued. I note that again, I'm going to go back to you one more time, and these are the words that I'm hoping will resonate with you and cause you to be a wiser man going forward. This wasn't about an unjust arrest, as you said at the scene. This is not a BLM issue. This is about you doing wrong things on that date, and to try to reflect them and deflect them to anybody else is extremely foolish behavior. So, Your Honor, the final thing I note is that, again, as I said, I'm going to be very frank and very harsh to this defendant. If you try to get into law enforcement and they ask me about it, I'm going to say no. So you've got some strikes against you, and maybe you'll make it anyways. But if they come back and they ask me what I think should happen as far as a law enforcement career, I'm going to say no. That doesn't preclude you from doing a lot of other very good things with your chosen career. And I hope that you do well. I hope that 10 years from now, I see where you have done great things with your life. But again, bottom line, as I conclude, it's up to you. Be a fool or be a wise man. Thank you, Your Honor.
Ms. Anderson, Tara Conklin is the complaining witness here. I know Ms. Conklin. Never had any input from her. Do you have any input on behalf of the victim?
The victim was hoping that the defendant would receive help. She said that he's never, ever gained any help on his own, and she wants to see him get anger management, some sort of counseling. That's the direction she would really like to see him go in.
Mr. Williams, I regret that this case took as long as it did. You and Tara were arguing about, I guess, infidelity. He said, she said. They wanted to know where you'd been. You didn't want to tell them. The argument started. Things went downhill. When you're not married to the mother of your child, the mother has paramount custody rights to the child. So at that point, she didn't want you to see the child. I guess it was her right not to. This went over to her mother's house, and other things took place there. And Mr. Fitz commented on that. He's asking that I continue the no contact provision. And frankly, I'm not in favor of that. You haven't been able to see your child for a year. This is your biological child. and you've been prohibited for an entire year from seeing that child. Now, my regret is we should have gotten to the result we're at right now last July or even June, a domestic violence deferral and a probation. You're not responsible for the delay. You're to some extent a victim of circumstances from a prosecutor election, Mr. Marvin becoming prosecutor, the time delay in getting a special prosecutor appointed, Mr. Fitz is electing to charge it as a felony. We finally got to where we needed to be. But that's time you can't make up. You can't go skin to skin with your baby. You can't whisper to him. You can't do the things that you've lost. And I'm not going to use this process to prohibit you from seeing your child. Tara does believe that you need some help. I don't know whether you and she are going to have a relationship or not. But let me repeat, when you're not married, the mother has paramount rights to the child. So if she's not going to let you see that, and now this child's a stranger to you. You're somebody the child doesn't know. He doesn't know your smell. He doesn't know the sound of your voice. He doesn't know the things that infants do when they bond to their parents. And that's very regrettable. To my knowledge, you've never missed one hearing. You've probably been here 22 times. I don't even know how many times you've been to this court. But Mr. Fitz came down pretty hard, but he said a pretty wise thing. You can either learn from it and get wise or resent it and be unwise. This is your opportunity to do this probation, have this charge removed from the criminal record. The disturbing the peace charge would stand, and try to build a relationship with your son and the mother of your child. So, having said all that, is there anything you want to tell me?
Are you speaking to me, Your Honor?
Yes, sir.
The biggest thing I just want to say is it was definitely a series of unfortunate events that occurred that night and some misunderstanding that took place. But most of all, I'm a full-time dad. This is actually my third child. I actually have court order visitations over one child. I drive back and forth to Ohio every other week to pick up my second child. I'm a student pursuing a degree in digital forensics. I already have my associates in computer programming. It was just an unfortunate moment for myself, and I definitely learned through the process that it took to get here today. And I'm definitely understanding where she might want to seek anger management and counseling, and that's definitely something I completely understand and open to. But at the same time, I definitely plan on pursuing a relationship with the mother of my child and becoming a great father figure for my daughter, which is she just turned 1. And
I kept calling him a son. Apparently it's a girl. I'm sorry.
Yeah, this is my firstborn daughter. And I missed her birthday and everything. I've been out of her life for a year, and I just want to spend the rest of the time I can making up for that. It was a series of delay in the process, and it was just a bunch of information that it doesn't reach full integrity, I believe, and it doesn't define me as a person, because that's definitely not the man I am that Mr. Fitz made me out to be. And I definitely going to take a full advantage of the opportunity you give me today, Judge, to show you that I'm a completely different person than the paperwork says. And I'm 30 years old, never been in trouble. And I didn't just pick a day. Decided to get in trouble. Obviously, the whole thing with my daughter is Tara and I just wanted my daughter back, and it was a complete misunderstanding, being that her grandmother is our neighbor, and I go to her house every single day. So it was just a complete misunderstanding. And I do apologize for my actions, and I can't wait to get started on being a father to my child or learning from my mistakes.
All right. Well, I think you said it pretty well. I'm going to do the sentencing on the disturbing the peace, 1 day in jail credit, 1 day concurrent with the domestic violence charge. There's 0 fine on that charge. We have a domestic violence program here in St. Joe County. I think you're very appropriate for the anger management probation. I'm going to put you on probation for 12 months. This case has gone on for a year as it is. You can complete the probation early. Under the new statutes, you can do a 12-month probation in 6 months if you complete all the conditions. Let me repeat, if you successfully complete this domestic violence probation, the charge will be taken off your record as a public record of conviction. You seem like an intelligent guy. You're completing college coursework. I think you can complete our anger management class, which is highly respected. I've talked to hundreds of people that have been through it, and I don't think I've talked to one person that said they didn't think it was worthwhile. I'm going to order 11 days jail credit 1. Of the 11 days, 10 are deferred. You're not going to do any additional jail time if you do what I ask you to do and comply with the terms of your probation. Fine is 0. This isn't about so much fine. There's a $75 crime victims' rights fee, a $50 state minimum fee, a $150 attorney fee, $480 probation oversight fee. It's $40 a month, and you're to pay for the class. Class is presently online. So many things have gone from the real world to the virtual world. Ideally, people would all be in the same room, but the report I got just this week is the classes are going very well. Our new instructor is doing a good job. She enjoys doing it. The people enjoy being in the class. So you've got to complete the anger management class. That's the significant condition. The next condition is no assaultive or threatening behavior towards the complainant in this case or any other person. You're no longer on bond. You're now on probation. And I'm lifting the no contact provision. If you're ever going to have a relationship with your daughter, you need to start it. But you can't use any alcohol or any drugs, and you could be tested if the probation agent requests it, and you can't engage in any assaultive or threatening behavior. That's less than domestic violence. That's yelling and screaming and threatening and that sort of thing. So we're going to deal with those issues as part of your anger management. I have not spoken to Tara about this. Miss Anderson did, which is helpful. I believe I may have heard from her at the early stages of this. The sooner you can get this class completed, all your fines and costs paid, the sooner you can get off this probation and get on with your life. I'm going to have the probation department contact you. You're still out at your dad's on Boone Road?
Yes, sir.
Phone number still 9608?
Yes, sir.
All right. Right now, you're kind of dreading this class. I've had many people that when it was over, they didn't want it to stop. They wanted to keep dealing with it. It's going to help you be a better dad, a better partner. I'm not sure, you've got, I guess, 3 mothers of 3 different children. It's going to help your relationships with them. And if you do it, this won't affect your ability to, I guess, use or possess a firearm. I don't know if you're a hunter or a target person, but domestic violence would take away your gun privileges, which is in effect while this happens. I also think you could be a role model for other people in the group. You seem like an intelligent, articulate guy that can speak your mind. You just can't do this sort of thing or you end up in the crosshairs. All right, Miss Anderson, if you would let Tara Conklin know that the no contact provision is lifted. If she doesn't wish to have contact with you, Deontay, she doesn't have to, but she's allowed to. And right now, you don't have any sort of custody or visitation order. And as I indicated, this child's a stranger to you. So you're gonna have to build that relationship step by step. Being in the anger management class is gonna be a help to that. All right, is there anything else we should put on the record here?
Judge, apologize on this, and again, I danced around a little bit, and I should have mentioned it earlier, but in regard to the victim, certainly she will understand the fact that there's a right for, or should be some opportunities for him to re-engage with his child and so forth, but she currently does not wish to have contact with him and would ask that he respects that. She'll certainly work with him as far as visitation and so forth, but at this point, she does not want to have contact with him.
All right, I wasn't clear on that.
Excuse me, can I ask where he's getting his information?
This is from our victim coordinator speaking directly to her, including today.
The discretion is going to be with Tara. If she wishes to have contact with you, she's free to, but I'm not compelling her to do that. But my point is, if you and her go to McDonald's and talk about custody and visitation, you're not going to be in violation of your probation. Right now, if you did that, you're in violation of your bond. So if she doesn't want to talk to you, she doesn't have to. But if she does, you're not going to get in trouble for it, as long as you don't engage in any assaultive or threatening behavior. All right, we will complete this session. Thank you all for being here.
Thank you, Your Honor.
Thank you.
See you again, Paul. See you, Vic.
Good night, Judge.
Mr. Williams, best of luck. All right, that completes our morning docket. We do have a hearing at 1, and